I'm so happy to be here with you all today. Thank you for joining us. We have a very important and timely topic today, and we know the stakes are high and the market is super hot, so it is more important than ever to be vigilant about contracts and business best practices, which is, I know, why you're here today. I am so happy to introduce to you our two guest speakers. We have Avis Wukasch, who you probably know, served as the chairman for the Texas Real Estate Commission from 2011 to May of 2019. And prior to that, she served as vice chairman of the commission for 2 years and 1 year as a commissioner. She served on the broker lawyer committee from 2001 to 2005, and she has been on the team developing the TREC non-elective courses for many, many years. She also teaches the non-elective courses sponsored by TAMU, the Real Estate Center. And then since 2001, she has been the broker for Keller Williams Realty in Round Rock and Georgetown, Texas. So thank you, Avis, for being here. We're so excited to get your tips and tricks in today's marketplace. We also have Kerri Lewis, who is a Texas real estate and administrative law attorney and published author. She served as general counsel for the Texas Real Estate Commission from 2013 to 2019. And Kerri first joined TREC as the Director of Standards and Enforcement Services in 2009 and was Deputy General Counsel from 2012 to 2013. So long time at TREC, lots of tenure there. Her career spans over 30 years and includes legal and management experience in both public service and the private sector. And she has represented real estate developers, license holders, and individual parties, as well as small businesses, financial institutions, the list goes on and on. Kerri is an experienced mediator, has been on the team developing TREC, also been on the team developing TREC non-elective courses for many years, and teaches the non-elective instructor courses sponsored by TAMU at the Real Estate Center. She writes legal articles for the Real Estate Center's quarterly magazine, and we are thrilled to have her join us as well. This is our second high stakes hot market session, and we are just ecstatic to have it back for you all. As Christine said, please put your questions in the chat. We will try to moderate them as much as possible. Please give me a nice round of applause. Welcome, Avis and Kerri. Thank you so much.
Thank you, Kalea, and all the Austin Board staff for all your hard work to make this be a seamless process, and particularly Kalea and Christine and the guys behind the curtain that we won't mention. And thank you, Chairman Horton, also known as my friend Susan, for serving the Austin Board as president this year. Kerri, what are we going to do? Start a little PowerPoint?
Yeah, I think we'll go ahead and what Avis and I, we have a presentation for you, just kind of general topics, and we'll kind of go through what we're seeing in the market and what we think about it. I'm a lawyer, Avis is a broker. We don't always agree, but on most things, when it comes to staying out of trouble, doing things the right way, we agree. We may come at it from different angles, but so you'll get some practical tips, you'll get some legal tips as well. So I'm going to go ahead and do the whole share screen thing. Let's see, make this work. Sharing my screen.
You've been practicing this with tech all morning.
I did.
Yay.
Okay.
You got it.
We got it. Okay. All right. So we're hot stakes, high stakes, hot market. And first question I have is, do current industry practices have you feeling like this every morning? This is not my typical morning, but I do have mornings like this.
It actually starts my day like that pretty much every day, Kerri.
Or maybe like this, right? See no evil, hear no evil, speak no evil. Just
there you
go. You know. So who are you going to call? You're going to call two old chicks on real estate. That's us. Funny story. Avis and I, TREC has a Halloween costume contest every year for the employees, and 1 year Avis and I went as the chicken and the egg. So
which came first?
Which came first? Yeah. So we had a little race around the boardroom table. It was kind of fun, but I ended in a tie, in case you were wondering. But one of the staff attorneys, when I retired, took our picture and placed it in this background for us, and I just think it's hilarious because she knew we were going to be two old chicks on real estate. So anyway, today we will discuss current industry practices that are ripe with risk and give you options to reduce the likelihood of needing an attorney to defend you in either civil action or administrative action. Avis, if you've been in any of our courses or ever heard Avis speak, she always says, I don't want to be the test case. We don't want you guys to be the test case either. So we're going to go through a series of topics of things we've seen. And Avis is going to kind of tell you what she sees that's going on in the industry right now. And we'll kind of talk through what our thoughts on that matter. So our first one is listings and MLS. So Avis, you want to kind of hit some of the high points on this?
Well, these things have been coming up. Yes, Kerri, yesterday I got a call on a mineral estate and mineral leases and who owns the mineral rights and all of that stuff, which we didn't even put on here, but that is in new paragraph 4, how all the information that the seller has on anything of that nature needs to be conveyed to the buyer so they know what they're actually buying. And we don't probably have time to get deep into a mineral discussion, but these things happen, everything all the time. And just to remind you, if you're going on a listing appointment and the seller has already told you that this property is occupied by a tenant, if you haven't yet studied the new lease addenda, get it out, read it several times. It's a little confusing. You need to be very careful how you use it. Then you need to take it with you on the listing appointment and provide it to the seller. And I'm whether that means a piece of paper or that means you've sent it to them electronically, they need it in their hands right away, because the buyer has some outs if they don't receive certain things prior to getting in this contract. So pay attention to that.
And also seller has some new obligations under that addenda.
That's true.
Affirmative statements that they have to make. And if they can't say that they're true, they have to say why. So they need to know up front what they're dealing with. And if they need to get the information together for any of the exceptions, they need to know that as well. And you need to know that. It may help you advise them on how you want to market the property.
Correct. So find out if it's got a leased property before you go out on a listing appointment, because you need to know that. And of course, there's a whole bunch of new stuff in the new contracts about smart homes and all sorts of electronics and all kinds of things, and what stays and what goes and who does what and how do you turn over what to whom, and just be fully aware of all of those changes to the contract and the addenda that bring in smart information to our world. And
Avis, can I just add, because I know we said lease addenda, but fixture addenda, if you're on a property that has fixtures, fixture leases, take that addenda as well, because again, it kind of goes through the obligations of the parties depending on whether they assume those fixture leases or not. And that's another one that, in terms of the addenda, that I find even more confusing, because it goes between what's on the property, what you're assuming, what you're not assuming, what happens if you do assume, what happens if you don't assume. You can have some of each. So again, it's one of those, if you haven't started using it yet, and you may not have, take the time to read it several times and go through it bit by bit. And I will do one quick plug here, is Avis and I are actually doing an addenda course with ABOR on July 6th, and we're going to go through all the addenda. So if you hear us mentioning addenda and you don't have a lot of comfort with the things in certain addenda, we're going to go through each TREC promulgated addenda during that class.
In the afternoon, 1 to 5.
Yep.
So, and it counts for the at least 3 hours of contracts required for your license renewal too.
Yeah.
So that's all good. That's all good. Yes, all of those things are true. What should and should not go in MLS? Well, if you do have a property that's leased and you get a copy of that lease to provide to the buyer, that is not something that you should upload into MLS, because that could be, there could be privacy issues with that. The buyer does need to get that if they're going to be taking over that thing. However, the lease is not one that should be there. And I don't think that it should be there even in the agent view only, but that you need to ask your broker about, not me, unless I am your broker and I'm telling you not to do it. So there. Lots of things that should not go in MLS. And I think
with fixture leases too.
Yeah.
Because you've got a third party lessor who may take offense to you putting his lease or her lease, company's lease, whatever it is, on the MLS, which could be considered a public forum.
Yeah.
So just be aware.
One of the things I've seen in MLS a lot in the last several months is something like the seller is going to receive an offers until Sunday at 5 p.m. and then they will look at all offers. Two things about that. If that's what you have published and said in advertising, you need to not let the seller sign anything between whenever that is in there and Sunday at 5 p.m. Because everyone that you have announced that to could have a ethics cause to claim against you because you didn't hold true to what you said you were going to do, and their buyer missed the opportunity because they hadn't seen it yet or hadn't gotten their offer there. And also from the standpoint of the commission, all offers written to the seller have to be presented to them. So even after the seller takes an offer Sunday at 5 p.m., every offer, unless the parties have agreed otherwise in writing, all those offers have to continue to be presented to the seller all the way up to the day of closing. And I think that's one of the offer deadline things you wanted to talk about. And I kind of wanted you to talk about offer guideline sheets, because I think you do a really good job of presenting that.
Yeah, and we may have touched on this in our last high stakes. I know we talk about this when we go up because I think it's important. In a hot market where everybody's getting inundated with lots of offers and maybe overwhelmed, there's a tendency to set guidelines in MLS that say we will only accept an offer if it's X, Y, and Z. You know, this much earnest money, this much option fee, this many days to closing, on and on and on. And two things I want to say about that is, first of all, those guidelines need to be seller driven. They need to come from the seller. You can have that conversation with the seller, but the seller needs to be fully informed when agreeing to that, because the seller needs to know that the more restrictions you put on accepting offers, the fewer offers the seller's going to get. And there could be offers outside that box of criteria that have been set that are actually the best offer. It's just something that may not fit in a preconceived box of terms. The other thing that you really need to be aware of is that you could be running afoul of the appraisal and the auctioneer's statute. The reason that auctions can happen online, they can happen serially with sealed bid offers, or they can, the way we all think of it, somebody up there going as fast as they can with their words and doing the actual auction. Auctioneers cannot do the real estate side of a real estate transaction. They can do the auction side. Likewise, real estate agents cannot do the auction side of it unless they are also licensed as an auctioneer. So be aware that if pretty much the only thing that's left from your offer guideline is who's giving me the highest price and is it cash or is it finance, if that's pretty much all that you've left for the buyers to bid on, you could be considered to be doing an auction and need a license. You need an auctioneer's license. So be aware, the only reason real estate agents currently aren't is because there's exception in the auctioneer's rules that says, serial offers on real estate property, you don't need a license from the auctioneer department because the terms of the offers are different, not just the one term of the price, but there's various terms that can be different in any offer. So just be aware, if you do offer guidelines, that your seller's aware and that you are not being overzealous in your requirements. Okay?
Cool.
All right. Agent hopping. You want to tell a few stories and then I can talk to them about contract stuff?
Well, it's at least once a week, if not more often, and which means, I don't know what it means, that I get a call from somebody who has been working with a buyer who has signed a buyer representation agreement. They've shown them several properties. They've written offers. They've done all kinds of things. And the agent takes a couple of days off to do whatever they might need to do, tell the buyer they're going to be gone for a couple of days, and the buyer walks up and buys a house from someone else. I don't know what we're doing as an industry to cause buyers to not understand that a buyer representation agreement is a binding contract. I don't think we're doing a very good job. Surely not every time I've heard this has just been a thing of amnesia. And maybe occasionally an agent doesn't do a very good job and the buyer has the right to ask to be turned loose. But this has almost become epidemic, which is kind of a weird word to say today. But I'm real concerned that we are just throwing papers in front of somebody or sending them a buyer rep agreement through whatever .loop or zip forms or whatever you're doing, and they sign it rote. They have no idea what it was that they signed, and they don't understand it's a binding contract. You know, I can take a position as someone who's not a millennial that they're a millennial, and so they don't understand what a binding contract means. That's an old person's joke. So all of you people that are my age or older, you can laugh about that. But please do a better job of helping the buyers that you represent understand that this is a binding contract and you're going to work for your money. And when they do that thing to you that I just described, they really put us in a bad place, because you know, you got two choices. You can pursue the buyer under the buyer rep contract and go to court and make everybody mad. You can pursue the listing agent or the other buyer's agent for some kind of referral fee to try to get them from getting in the middle of all that. It is just an ugly situation and it's very difficult. So Kerri and I have had a lot of conversation about how to make this better. And one of the things we've come up with is to let's try to start training people to do a better job of using the information about brokerage services form as the beginning tool and explaining carefully what all you're going to do and what all it's going to mean, and that you're going to ask them to sign a contract that will bind them to you for a certain period of time. And I don't know, maybe it'll help. And on the flip side of that, I'll let you do the flip side of that about when an agent doesn't perform and the buyer just wants out.
Yeah.
What can you hold them hostage?
Yeah, and that's where I think fiduciary duty comes in. Recently heard of a situation where this happened and the agent didn't really perform or didn't perform at all, but had a signed buyer's rep agreement. And the buyer says, you know, you're not doing anything. We want out. We want to go with somebody else. And the agent said, no, you signed this buyer's rep. You can't use anybody else. You got to use me. And it was really a long period of time, like 6 months or something for a buyer's rep agreement. And so the buyer was in the position of, do I want to hire a lawyer to get out of this? They're not performing under it. And I don't want to work with this person. I've lost faith in this person. I don't think they're responsive. I don't think they're capable. And so do you want to spend the money on both sides, on the broker side and on the buyer's side, when remember the fiduciary duty says you put your client's interest first? Now, I know you have a contract that gives you the right. And I would say practical solution, okay, let them out of the contract, just like if you've got a listing agreement, let them out. There may be a monetary payment that's due to you. There may not be. If you, in fact, showed them something, you know, you can let them say, however, if you buy this house, or this house, I will still get this commission. But to hold them hostage for a 6-month period, I think is a breach of your fiduciary duty. And I think it's a lawsuit you can't win, especially if you as the agent has not really performed. Now, it could be you performed great and these clients are just thinking they can get out of paying commission. Well, that's when you want to stand on the terms of your buyer's rep agreement, but you better be able to show that you did perform and that they understood that this was a binding contract. So again, practical solutions Avis talked about is, you know, work something out with your buyer, like I talked about, or work something out with, if a new agent is going to be showing them, say, you know, just give me a referral fee, you know, or something. Or just, like I said, it's really a tough situation, but if for some reason it's happening a lot now, but it's not worth the litigation. It is not. And I'll tell you the other thing, and this isn't a legal thing, but it's just my opinion as a consumer. You're damaging your reputation because that person is going to give you more negative PR than you want to everybody they know, because they're going to be really mad that, you know, they didn't feel you did the job, and then you were making it very hard for them to buy a house using any other agent. So anything to add to that, Avis?
Nope, I think you did a good job on that.
Okay. All right. Contracts. We got a couple of different slides on contracts. This is just kind of the general thing. Ignorance is not an excuse. Everybody knows we've got the new contracts now. If they don't, everybody on this call, I'm sure does, because you guys are real diligent. But there are still going to be what Avis calls the great untrained that don't help educate them, have them resend an offer on the proper contract forms. It's really important to use the contract forms, the new contract forms that went into effect April 1st. Read the fine print, understand what's in them. Deadlines are even more important. We're going to talk a little bit more about that in a second, especially with the option money, and deadlines that have been put in the 2 new lease addenda. Well, for paragraph 4, whether it's the lease addenda or the fixture addenda or the natural lease addenda, there are new deadlines that have to be followed and tracked. So that's important.
Kerri, I want to say one deadline thing, because I got a call about this yesterday. Always get calls about this. Every deadline in the contract, except one, ends at midnight. Every deadline ends at midnight except one. And that one, of course, is the time for a buyer to give notice to the seller that they're walking away pursuant to their right to terminate, now in paragraph 5. And that's the only one. Every other deadline, we didn't get our loan done. The property didn't appraise. All of these deadlines created by the new addenda, all are midnight, including when you take the money, send the money, get the money to the title company.
Yeah,
So.
good point. And then my last little picture is sense nonsense. Again, people are kind of crazed, and be the steady reality check influence on nonsense not going into the contract. You know, when things have just gone too far, take the emotion out, be logical, be practical, talk about pros and cons for some of these things that really are not going to serve your client well in the end. So there's two, you know, you might be able to give some examples, Avis, but to me, it's just, it's a good thing to do. So let's talk a little bit about money matters. Money seems to be kind of leading people off a cliff these days in this crazy market. But you kind of started, we mentioned a little bit about option fees. So Avis, you want to talk about the option fee new job for a listing agent?
Yeah, for sure. Of course, we all know now that the original option fee goes to the title company, and the title company will receive it and put it in the bank whenever they get it, whether it's inside the deadline or not. So the listing agent's job, and I hope everybody on this call knows this, and I hope you're helping people learn this. The listing agent's job is to verify that the option fee was delivered timely. Because if it wasn't delivered timely and you don't give notice to the buyer, or you and the seller don't have a conversation whether the seller is willing to accept it late or not, you're really risking some things for the seller in allowing an option period that may not have been valid. So the option fee is not delivered timely and it's accepted by the title company, which it will be.
It's not their job.
It's not their job.
Whether it's late or not.
You find out on the 4th day that the option money is just now gotten there, you need to call the seller and say, are we accepting this late? And then the seller tells you what to do. And if the seller says, well, no, I don't want to give them an option if they didn't get the money there timely, then you need to tell the title company and the listing and the buyer's agent, the option fee was not received timely by title. You do not have an option period. Your job as a listing agent, kind of a tough job and a good one, but and maybe an unintended consequence of all of this mess. But anyway, and kind of going down that same path, if there's no option fee, there's no option period. This is driving me crazy too. In your crazy world where we're all doing all this and people are paying too much and everybody's in a big fat hurry and they're doing a 4-day option period and they can't get an inspection. They finally get the inspection and they haven't gotten their money there, and they do the inspection before the option money and earnest money have been delivered. And they look at the inspection, they say, we want out. And they haven't tendered any money and they walk away. Technically, legally, they don't have an option period if the money hasn't been tendered. But what are you going to do? Well, it's up to the seller. What are you going to do? That option money needs to be tendered in order for there to be an option period. We have a question in the chat. When does the seller get the option money? Most of the title companies have a 10-day hold on that, a 10 working day hold or a 14-day hold on the money to be sure that the money has cleared the bank, particularly if it's a personal check or a cashier's check. If it's a wire, they may not have that hold on it. And so the seller has to make demand for the option money if it's going to be received by them. It doesn't automatically go to the seller without their request of it. And
it will go at closing if they don't request.
Well, yeah, until closing, but it doesn't go to the seller like it did when the real estate industry agents and brokers were in charge of the tender.
Exactly.
So
another question that we got in a class the other day that I thought was really interesting is like, with the inspection, with the situation that Avis just described, somebody they put a large option fee down, short option period, but they got the inspection done before the option fee was due. And they decide that, oh, wait a minute, we really overbid on this. And, we want out. Okay. And so they don't want to pay that large option fee now. So they just say, we're canceling it. Well, under the contract, you can't. From a practical matter, the seller could call them in default and demand specific performance for them to pay that option fee before they would have the right to terminate. And then they've got to make sure that they get it in time. The other question that we got, and the seller may or may not want to do that. And that's, again, why it's the seller's choice. Right? You got to talk with your seller. What do you want to do? Because the seller says, I got a backup contract. I'm just going to go with it. I'm not going to waste my time and attorney's fees and tie my property up. Just because you have the legal right doesn't mean that it's the right choice for the seller. So the seller you need to discuss with the seller what they want to do. The other flip side of that, we had a listing agent say, can my seller refuse to allow the inspection until the option money is received? And that's a real interesting question. And I'm not sure we came up with a good answer for that. The contract says that the buyer has the right to inspect the property at reasonable times. So it doesn't say after the option fee has been paid. Okay, so it's not tied together. And like I said, there are other remedies in there, but if it's a short option period or it's a large option fee and the seller's afraid this is going to happen, could it just not be a reasonable time for the seller until that time frame? It's going to depend on the facts of the contract. If the option fee is due in 3 days and there's a 10-day period, maybe. If the option fee is due in 3 days and there's only a 4-day option period, probably not reasonable to make them wait. So in this crazy time, again, the seller just needs to kind of understand what's going on, understand what their rights are under the contract, point them to the contract provisions. I know you guys can't interpret the contract, but you can tell them that your rights are here if they don't pay, this is a default, here's the default paragraph, kind of thing. But do talk with them about that.
Kerri, we got 3 questions in the chat, and I know that 2 of them are for you.
Okay.
Here's the first one.
Okay.
Can the seller refuse the inspection? I assume that means that they get an amendment requesting repairs in the inspection. Can they refuse the inspection if the option money has not yet been received?
I don't think that they can that's what I was just talking about. Refuse to let them have the inspection, or refuse to negotiate about the inspection items.
I just read you the question.
Okay. So we already talked about, can they refuse to let the inspection come in? That's kind of a gray area right now. They may or may not get in trouble depending on how reasonableness a court would hold that it is. And then if the inspection's done and the other party is negotiating to change within the option period, as the agent, I would remind the other agent is listening, I would remind the buyer's agent, says, there's no negotiating at this time because your client has not paid for that option fee. Therefore, there is no valid option period to negotiate during. I think that's how I would approach it.
Yeah. Okay. If the buyer wants to terminate before the earnest money is due, can they pay only the option money to title and then terminate? Or do they have to pay option and earnest at the same time and have the title company reimburse the buyer for the earnest money?
Okay. Technically, under the contract, the binding contract that the buyer has signed, the buyer is obligated to deliver the earnest money and the option fee. Now, if the buyer has delivered the option fee and is 100% sure they are within their rights to terminate within that option period and receive a full refund of the earnest money, then the answer is technically they're supposed to deposit it. Practically, no one's going to make a fuss about it unless there's some other reason that money should have come out of that earnest money. For instance, one of the changes that was made to paragraph 18 for the escrow section clarified that if you are due the earnest money back, but if you had an obligation to pay a fee or under the contract and the title company did that for you, or you asked the title company to order the survey for me, and I've got the obligation on there, but you order, the title company orders it, the title company is not obligated to pay that surveyor, you terminate as the buyer and you get your earnest money back, you will get the earnest money back less the amount of that survey. So there's a reason why either the title company or the seller may say, no, you still got to put that earnest money in because you have an obligation. And again, from a practical matter, is the seller or the title company going to pursue a lawsuit over this? You might get a letter, but are they going to pursue a lawsuit over this? Probably not in a hot market. But keep in mind, don't develop bad habits just because it's a hot market. The market is going to cool down. And then when you don't have, 10 offers to 100 offers on a property, these things may become something, that the seller wants to litigate over. So just keep in mind the legal, you're supposed to do it. The practical may not be as important in the current market, but somebody could legally hold the buyer's feet to the fire if they wanted to pursue it.
Okay, one last question. If there hasn't been consideration, is it actually a contract?
Earnest money is not the only consideration. In Texas, you can have zero earnest money and still have a binding contract. Okay? Earnest money is part of the consideration. The promise to buy, the promise to sell is also consideration that has been held in Texas courts to be enough consideration to have a binding contract.
So I'm going to wind us back to the PowerPoint. So Kerri, my seller wants this earnest money to be non-refundable.
Okay. First of all, do not put non-refundable earnest money only in your seller guidelines that you put up on MLS, because one, you are going to be, could be sanctioned for practicing law without a license. If you've told your seller that that's okay to want that, and you put that in, you're risking some sanctions. If my seller said that to me, I would say, probably not a great idea. You might want to talk to an attorney, because if I'm a buyer's agent and I get that, I'm certainly going to recommend that my buyer talk to an attorney before giving that up, because the earnest money can be refunded in so many different scenarios that happen under the contract. Casualty, for once, the house burns down. You don't get your earnest money back. The seller doesn't, you don't get your earnest money back. You don't have the right to terminate and get your earnest money back. That's a big one. But the seller's disclosure was never delivered. You don't get your earnest money back. Making the earnest money non-refundable changes the rights and remedies of the parties in so many instances. So I think it's a horrible practice. I think it's especially a horrible practice for buyers. I don't think they really realize what they're doing. And for sellers, if you're doing that, you're really going to cut the market for any sophisticated or any buyer who actually reads their contract, because it gets scary. It gets scary to do that. And
you're surprising me a little bit, dancing all around, not just saying, well, you can't do that, and it's the unauthorized practice of law for you to write that, so get out of my office. That's what I thought you'd say.
The only reason I was dancing around that a little bit, because that's what I was trying to say for the agent. But if it is your seller's idea and your seller instructs you, I think you have to follow that seller's orders as a fiduciary. But I think you have a duty to say you're going to limit your marketability of this property.
Okay, we have another question in the chat, and I don't know the answer to one.
But if you do write it as an agent, you better have it in writing that it's coming directly from your seller and they're requiring this, and that wasn't your idea.
I mean, why go to all this trouble? Just make it option money.
Yeah.
I mean, come on. I don't know the answer to this.
Yeah,
we may have to
more
get
option money.
Right. We may have to get back to the asker on this question, because it says in a lease, do you have to have a dollar amount to have a binding contract? And I'm going to have to look at the Texas Realtors lease document to know the answer to that question.
Yeah, because TREC doesn't.
Yeah, I'll get back to you on that. Okay.
Yeah. And I would think that it would be similar. I think you could draw parallels to the contract cases that are case law today. But
so, Kerri,
I haven't looked at a lease case. You're right.
Going on, I didn't talk to the seller about this, but I just decided, even though the house is worth probably would bring $650, we're going to put it on the market for $475, and so we listed it $475 so that we can get everybody to see how high they'll go. What do you think? Didn't tell the seller.
Yeah, no, that's a huge problem. First of all, that's a huge problem. You're supposed to do a CMA. They're supposed to know what the real market value is. You've breached your fiduciary duty to your seller. I did hear of a case, and again, this was in one of our classes, and this is going to start on this slide and go to the next slide because it involves so much. But the start of this scenario, and this was a real thing that just happened a week or two ago, was I'm the buyer's agent, and the listing agent told me that they listed it below market value to try and generate a lot of attention and get people to bid against each other. And so the first thing is, one, the seller's agent better have talked about the pros and cons of doing that with the seller and make sure the seller agrees. One, should have given the CMA, and two, should have discussed it with the seller, the pros and cons of it. to make sure the seller agrees. And I still think even if you did that, it could be, if the only offers they get are still below market value, I think you're going to have a very mad seller who's going to blame you and want to ditch you and your listing, and probably have a very good case to do it and go with somebody else and list it at what the market value is. So I think it's a terrible practice, number one. Number two, this listing agent was friends with this buyer's agent. And did this listing agent just tell this one buyer's agent, or did they tell everybody that was going to put an offer in? Again, you're not treating all parties to the transaction fairly or honestly, violation of TREC canon of ethics, and also violation of TREC rule, which says you've got to treat all parties to the transaction fairly and honestly. So I could even say listing below market value as a marketing ploy, if you will, isn't treating all parties fairly and honestly, in addition to perhaps violating your own fiduciary duty to your seller. So it's a horrible practice, in my opinion. I think you can get in a lot of trouble, not just with TREC, but with civil lawsuits. You are asking for a lawsuit if you're doing that.
And I don't know that everybody thinks, well, probably nobody thinks like I do, but I don't know that everybody thinks about, it's not just what we're doing right now that's the problem. It's when that time comes, when there's a shift in the market and a buyer has got a problem with the house, or the seller's got a problem with what happened, and suddenly starts thinking about, well, my agent's responsible for that. And then here it comes, the demand letter, that kind of stuff. That's
yeah.
So anyway.
So let's talk, we're talking about market value and list and, sales price and all that stuff. Let's talk a little bit about the appraisal addendum and an FHA and VA financing. And Avis, if you would do a little bit about the three choices in the addendum and kind of the reality check that maybe, agents should be doing with their buyers today in this frenzied market. And then I'll talk a little bit about why you can't use it for VHA loans and all of the stuff that goes with that.
Well,
FHA, VA loans. Yeah.
The use of this form, I don't think was thought of. I don't think when broker lawyer created this form that they presumed this market would happen, where people are just paying ridiculously high prices for things. This form came from, there was, prior to this form, only one situation where the buyer didn't have some protection when there was a low appraisal. Because in the third party addendum, there's the negotiation part of that in every situation except a high down payment conventional loan. So that's where this came from. And now it's just gotten kind of insane. And of course, the three choices are that the first choice, which in layman's term is no matter what happens, no matter what the price difference is between the price I've contracted for and the appraised price, I will pay the difference. That's what the buyer is attesting to. I'm totally waiving my right to walk away. So I'll pay anything, period. The second choice is the choice of limiting what that difference might be. I will pay only X by establishing in there the opinion of value has to be this much or more. And so if you have your price here and it's, say you have your price is $350 and you put in there $325, then you're saying I'm willing to pay an additional $25,000 or anything in the difference of that. And then the third choice to me is very similar to what is in the third party addendum. It does add a place to put in an amount, and it also requires that the appraisal be delivered to the seller. I would have been more comfortable with this form if they'd have just added that to the language in the third party addendum that deliver that and put that third choice. I don't think it does much for anybody.
Yeah.
So now you do the whole.
Yeah,
don't
I
validate-
think also though that third one is there for that high cash, high
Yeah.
down payment person,
But
because
they're all kind
putting
of
a high down payment down, the
Yeah.
loan amount is going to be such a low loan to value
That's-
percentage that the appraisal is not going to be a factor, but they want it to be a factor, and that's when I think you would, because
Well, yeah, but it's very similar to third party. But
It is.
all three of those can be used, or were really presumed to be used in that high down payment situation.
right.
That you
Right.
still will pay that difference. So
Right.
go ahead.
Right, and they are being used, like you said, for everything.
Yeah.
So what I want to talk about, well, and then the other thing is if you've got a buyer who is just like, it doesn't matter, this is the third house I've lost, I'm going to put, just do box one, I'll just waive it, and if it comes in, and if it comes, I'm going to put $60,000 down more, and I don't care, I'm just going to do it. Do you, as a fiduciary, owe a reality check to your client? Have you done a CMA and say, just remember, it's your choice, but just remember, this is where my analysis comes in on the market value of this property. So, just understand that markets go up and down. This is a choice you're making. And so I think as a good fiduciary that you should do a reality check with them.
We have a question in the chat before you get deep into the VA FHA, and I want to get this question out of the way. If the
Okay.
buyer's the first choice to waive and the appraisal comes in extremely, I think, low, although low's not there, can the
Yeah.
buyer cancel and just forfeit their earnest money? Well, that's entirely up to the seller, because the
Yeah.
seller has all the remedies in the default paragraph because the
Yep.
buyer is defaulting.
Exactly.
So-
Exactly.
Maybe if the seller accepts that,
Right. If this,
Yeah.
or the seller could sue for damages,
all kinds of stuff.
court costs, attorney's fees, specific performance. No, you promised to pay $100,000 over it. I'm going to sue you. You're going to have to do it. That's why it's important to have that reality check.
Yep.
That reality check with them, and then double check, and then make sure you have an option period, and make sure that they know, have reconsidered during that option period. That's just what I would do. Okay, what can you not use this form for? I'm going to read it. It's right here. I've got the form right here. It's right at the top. I'm going to read it, then I'm going to tell you why I'm reading it. It says, use only if the third-party financing addendum is attached to the contract and this transaction does not involve FHA insured or VA guaranteed financing. I can't tell you how many questions we have got in the last 3 weeks, really, 3 or 4 weeks, is can we use this form if we have a VA or FHA buyer? And the answer is no, no, and no. You
But
cannot.
the lender said we could.
Yeah, and I'm going to talk a little bit about this. I'm going to give you guys a background, because we have heard stories where the lender says, yes, you can waive that. And we even heard one case where the lender said, I will get my attorney to draft up some language for the buyer so they can waive this appraisal contingency. Okay? They can't. And I'm going to tell you why. And I also wouldn't trust that lender anymore, because they are violating FHA lending guidelines, rules, and requirements. So let me just give you a little background here. So hopefully everybody understands the FHA and the VA don't actually loan money. Rather, they have approved lenders who qualify for FHA or VA guarantees. So the FHA and VA are guaranteeing that the borrowers will pay this back through mortgage insurance payments. Okay. So first of all, when you say FHA or VA loan, you're dealing with a regular lender, and you guys may understand this. Your clients may not. the VA and FHA are guaranteeing the loan these lenders are making. So there is a program, there is a guideline, there are rules and requirements that the lenders have to follow. And one of the things that was put into place, I think it was 1978, is something called an amendatory clause. The amendatory clause must be included either in the sales contract, or the buyer must, if you're in one of these two loan programs, or the buyer must get an actual HUD form. There's a HUD form for this that has this amendatory clause language in it before they sign the sales contract. In Texas, this language, and it's express language, this language has been inserted into paragraph 4 of the third-party financing addendum. So I'm going to pull that up because I'm going to read it to you. And I'm going to read it to you for a reason that I'll get to in a second. So it starts out, paragraph 4 says, and you fill in the stuff about the financing on the first page, but paragraph 4 applies to FHA and VA loans. If the financing described above involves FHA insured or VA financing, it is expressly agreed that, I highlighted this next part, notwithstanding any other provision of this contract, notwithstanding any other provision in this contract. So if the buyer puts something in special provisions, adds another addendum, doesn't matter, that notwithstanding any provision of this contract is going to override that. You can waive it somewhere else, but this says, doesn't matter where it says anywhere else, this buyer shall not be obligated to complete the purchase of the property described herein, or to incur any penalty by forfeiture of earnest money deposits or otherwise, unless the buyer has been given the that requirement sheet or a written direct endorsement setting forth the appraised value of the property of not less than blank. Okay. If the contract purchase price exceeds the reasonable value of the property established by the Department of Veteran Affairs or the HUD for the VA, and then the 3-day notice and the termination requirements in 2B do not apply to this paragraph 4. So basically what this is saying in English is, no matter what, the buyer has to know the appraised value of that property that's going to be acceptable to HUD or the VA before they can decide whether they want to pay extra. So preemptively waiving their appraisal right, their appraisal contingency, if you will, is illegal under federal law. It's illegal for the lender. It's illegal for the seller. Okay. And when I say illegal for the seller, let me put it another way, because I did a lot of research on this last night. Across the board, every state that I've read information on, and a lot of local boards have all said that if you tell your seller that they can accept an FHA or VA loan appraisal waiver, you're misleading them. You are misleading them because you cannot override this contract, cannot override this amendatory clause that is federal law. Now, what does this mean? We all know it's harder in this hot market for people who are in a VA loan or program or an FHA loan program. But remember, all that means is you kind of go back to the way things were. The VA or FHA loan person can bid higher than what they think the market price is. They can put that in the sales price. And they can put that, they need to put in this blank in paragraph 4, what needs to go there is the sales price, not the loan amount they want, the sales price. Because the amendatory clause rules also say that what's in that blank in that amendatory clause, that is the top limit of the loan the lenders in the program are allowed to give. Okay, so go ahead and put the sales price in there. Then if the appraisal comes in under that, under paragraph 4B and under the federal law, it's all the same because broker lawyer just copied what the federal law was and put it into this addendum. The buyer shall have the privilege and option of proceeding with consummation. Doesn't this sound like federal law? They just took it word for word. Of proceeding with the consummation of the contract without regard to the amount of the appraised valuation or reasonable value established by the Department of Veterans Affairs. All that means is they can decide to put in the extra money. The lender is going to be limited as to the amount of loan they can give. And it's going to be limited to the appraised value. If the appraised value comes in under that sales price, that's the amount that they can, by law, by federal law, that's the total amount that they can loan. But the buyer, if they have extra money, can put it in. The only difference is they have the right to make that choice after they know what it's appraised at. So you're back to that negotiation stage after the appraisal. So the buyer can just pony up the money. The buyer and seller can renegotiate the sales price. But that's protection that's been in place since 1978. And you can't just change it because it's a hot market and they want it. Bottom line is you just can't do it.
It's harder for FHA and VA buyers right now to buy a house.
It is.
And we all know that. And sometimes, at least some of our people that we have been dealing with in the Fort Hood area, try to find a seller who is also a veteran, and see if you can work something out, because because of this, it's hard.
It's really hard. And if you've got a FHA or VA buyer who's got extra cash on the side and they say, I can make up this difference, maybe, and this is me going out on a limb here, maybe the most you can say, and I maybe put this in the letter, be careful how you word it, and only if your buyer wants you to do this to help their case, maybe you can say, buyer has available funds to use if the appraisal comes in lower than the sales price. You haven't obligated or waived anything. And your seller needs to understand that buyer still has the right to walk away and get the earnest money back once that appraisal's in.
I would amend your language to either buyer may or buyer has some available funds.
Right. Yeah. Okay. Make it as wishy-washy as you possibly can if the buyer wants to do that. But the buyer is going to have to understand, and the seller is going to have to understand that no matter what language you put in there, even if somebody says, yes, I agree to waive it, and I'm writing this in here, and I'm going to follow up on that. If the appraisal comes in really, really low, that part of the contract is going to be overridden by the other part of the contract that says notwithstanding any other provision of the contract. And that's what I think people are missing.
Yeah.
Confuse everybody or clarify. What did I do?
Scary. It's scary to me. This is scary to me.
Yeah.
So, yeah. Well, let's switch subjects.
Yeah, you don't want to be part of that lawsuit.
I don't.
Because the buyer might sue or the seller might sue.
Or both.
Either side, as a realtor, you are possibly at risk of being in a lawsuit.
Yeah.
Okay, Avis, your favorite subject right now.
This one is all an equally difficult thing. I just feel so bad for all of you every day because you're practicing in this market and there's just so many things going on and so much pressure under you. And yes, very scary. The Property Owners Association, Homeowners Association form made a significant change, and I hope you're aware of it. This really needs to come down to some geographic competency on your part in knowing what the ridiculous fees are that the Property Owners Association will come up with, whatever they're called. They're called all kinds of things. If you've been doing this a while, you know that at one time, all of the fees except for a couple were all glommed together in one paragraph. And then the broker lawyer committee separated those out a few years ago and made there be a part of it that was deposits for reserves, which were buyer expenses, because it seemed somewhat logical that deposits for reserves for future improvements would be the responsibility of the buyer, because they would be the beneficiary of the future improvements. And that all the other fees were in a different paragraph. Well, latest version of this is they've gone back together. All of those fees are in one place. So except for paragraphs A and D, any other fees that there are. And A, of course, is the providing of the subdivision information. The subdivision information is defined in paragraph A, and you can read that and know what that is. And it's resale certificate and subdivision information and all that kind of stuff. So whatever that is, that's the responsibility of the seller. That's what A says. And D gives you a couple of choices on who's going to have those responsibilities. But then anything else that doesn't fit into those two buckets, anything else, you call it anything you want to. You can call it the bottled water fee, whatever the HOA calls it, all goes here. And that's your job to know what is that total number. Because if you're representing the seller, it's critical, because it says buyer shall pay any and all fees, deposits, reserves, for other charges for the buyer to transfer the property not to exceed something you put in there that's a dollar amount, and the seller will pay the rest of it, the excess. So that's important to the seller. What if that number that all of those total things is $2,000 and the buyer puts $250 there? I made a math problem for myself, but you've just given the seller a whole bunch of money he's going to have to come up with, and because they're going to pay all the excess. And got to read that carefully. And we've had some buyers and sellers already get bitten because the agent didn't clearly understand what this said, all of those fees. And I'm hearing my agents are telling me this. Well, the HOA is changing it and it's more than it was. And Stop whining and find out what the fees are. Just saying, stop whining and find out what the fees are. And stay on top of that. If you work in a particular 2 or 3 particular neighborhoods, or 10 or whatever, where there are HOAs, you should know that. And technically that should be public record, but that's another story. Just a side note, we do have a guy working on a 2 or 3 hour CE class all about HOAs. And so if we get that done, maybe Austin would want us to teach it for them. We'll let y'all tell them whether or not you think that'd be a good idea. So anyway, know what those fees are. So Kerri,
know what they are. That, as Avis said, that's part of your geographic competence. I don't think there's any way you can get around that as an agent. Okay, our last slide before we turn it over to questions is title company hopping. And this is a topic that we've talked about, and if you've had legal update 2 already this go round, you've heard about this, but I think it's important because in a hot market, this is happening a little more. I love this picture, but Avis says this every time we have a class. The contract isn't terminated by notice alone. Just sending a notice of termination doesn't terminate the contract necessarily. You have to kill it. You have to kill it. So affirmative action has to be taken by the other party, either releasing the earnest money or possibly saying, I don't think you have this right under the contract to terminate. They have the ability to do that. So in a rush where you've got backup contracts and maybe nobody's signed off on the release yet. And so you think, oh, we'll just go to another title company to do the second contract and we'll work this other one out. I'm not worried about it, but title companies can't have 2 open contracts on the same property at the same time. That's their rules, and they're rules for a reason. So if you come up with the great idea that you're sell it to your seller, let's just take it to another title company and do the backup contract or get another contract. It's a bad outcome for either the buyer or the seller, but this is definitely a no-win situation. And just as review, let's say that you've got backup contract number 1 and the first contract gives you notice, I don't want to, we're not closing. And for whatever reason, the seller says, I'm not giving the earnest money back right now. First of all, again, practically best thing, if you've got a backup offer sitting and waiting, just release the earnest money and move on. But people get upset about all kinds of things, or maybe the next offer isn't as good. Who knows? But if you do go to close at another title company and the second buyer knew about the first contract and knew that it was at another title company and it hasn't been fully terminated yet, that buyer, even though they bought title insurance, doesn't have title coverage, because there's a clause in the title policies that say doesn't cover any known defect known by the buyer at the time the policy was issued. That's a known defect that's at the time the policy was issued that buyer knows about. So if that first buyer ends up winning, maybe seller terminated the contract and buyer says, no, I'm going to fight for this. So maybe, you know, whatever happened, that first buyer wins the right to buy that property. There's nobody to protect that second buyer, and they're going to lose that property, and they're not going to have any recompense from anybody, title company especially. Okay. The second situation is, let's say the second buyer didn't know about it, but guess who does know about it? The seller. So maybe the second buyer would have title insurance coverage if something happened and the first buyer won the right to get the property back after, say, seller terminated. The seller gives the buyer a general warranty deed that warrants title as good title. Well, the title company will protect that second buyer if that first buyer wins, but they step into the shoes of that second buyer, and it's called a right of subrogation, which means they have the right for whatever they have to pay to that second buyer. They can turn around and sue that seller based on that general warranty deed. So it's a horrible idea. If anybody brings it up, don't do it. Just use the backup addendum like it was meant to be used. Okay. And when it's terminated, you get into first place, and work with the same title company, and work with, you know, if you're the listing agent and and they want to go with the backup contract, you know, have a little practical talk with them and say, well, then let's just release that other earnest money and move on, you know, or go talk to an attorney to see what your pros and cons are, or your best financial stake is and how long it's going to take. But don't try to do two contracts at once. It's a mess.
Okay, I'm answering a chat question. One of the questions here is they've been in classes where they said you can't have more than one backup offer, and that's actually, go ahead, and I was fixing to ask you that. Only one backup, right, Kerri? Without an attorney. Without an attorney. Without an attorney, only one backup. Why? Because it's a promulgated form, and you as a license holder can't alter it. And if there's a second backup, that addendum has to be altered. First of all, it's got to say second addendum or backup, second addendum for backup contract, or addendum for second backup contract, right? And then there's things throughout the language that has to, you know, you have to add language that you come into play in that second backup position after the first contract falls through and the second backup, and the first backup falls through. All of that can be done, but only by an attorney. If you do it as a license holder, it's the unauthorized practice of law. So, yep. So we are to the open the mic and do stump the chumps section of this question and answer. You're muted, Kalea.
It's like hashtag unmute, right? I need a t-shirt that says unmute. Yeah, so thank you so much. That was a ton of information, and we got some great questions from the class and those that attended. Thank you all for attending. One question that I had, unless we have more come up here, is, you know, we have this unprecedented market. We've heard all of the things, and, you know, you both have worked in strong markets and weak markets. What are you telling your agents? What are you telling your classes right now with regards to, your thoughts on today's market. I mean, we don't see an end in sight anytime soon. We're hearing all the headlines. We're number one on all the lists. Just, with all of these nuances that you're talking about in your classes, just give us some thoughts on what you're seeing and what you're telling your agents and your classes with regards to the market conditions.
Well, we've said some of those things today, Kaleo, but appreciate you asking that question. Kerri said, don't learn bad habits. Just, the market will change. That's certainly something we're saying to all of the classes is don't learn bad habits. Just because it seems like an easy path, don't press the easy button. Keep doing things correctly. I would say this is not very concrete and black and white, but this is something that I'm telling agents, which is this is a time in your life when you need to be full of grace, because people are crazy. I'm sorry, cray-cray, just like, whoa. Agents, buyers, sellers, everybody is a little bit like nutty and crazed. And everybody, I mean, our industry needs to be taking their medication and staying calm or something, because they'll be the only people that can be calm in this and just keep people from. Kerri talked about that. When you're with a buyer who's in this frenzy of getting this property and they're just wanting to pay whatever, I gotta have a place to live, my kids, and blah, 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 what all the reasons are, and you just gotta make them slow down just for a second. And I'm sorry, you got a chat that says preach it, Avis.
Yeah.
But you just really need to slow down, and you need to say, everybody just get some grace here, get some grace. We're gonna do everything we can to help you find a property, but be smart at the same time.
Yeah.
And it's hard. I feel so much angst for everybody in the industry right now. And I hope you all have grace and that you receive grace from each other.
Interestingly enough, I heard I guess I was in the car today, and so I had an NPR on, and they had Texas Standard on, and they were doing something about the crazy market prices and what do we think it's going to, and they had Jim Gaines on from A&M.
Yeah.
And he said, this is a quote, "It's not sustainable."
Yeah.
It's not sustainable. The rate of growth will slow or even stall or stop. Now, he wasn't sure if prices would start to drop in the immediate future, but just like anything, and this wasn't what he says, this is what I will say, because I'm old enough, Avis is old enough to have seen several cycles. What goes up goes down, and vice versa. It will cycle back around. Maybe it's like the stock market, it goes up, and then it goes down, then it goes up a little bit, down a little bit, and then it kind of levels. You may still end up above where, we started a year ago or a year and a half ago before it got so crazy, but you may not be at the height. So again, I just think, make sure you're doing your comps, make sure you're doing those reality checks, because I think that you owe that to your clients.
Yeah, and I would just add on to that, just taking care of yourself too. There's when you're burning it all at both ends and you're just trying to do everything you can, and taking that time for yourself, taking that time for your families, and making sure that you're really doing that time management is always one of those things that I know busy realtors forget. It's the first thing that falls off the books, right? So taking care of yourself. We did have one question here.
About the Texas Realtors form 1926, invitation to submit a new offer, that form.
Yes.
Yeah, we have a question that says, could you review best practices for the use of that form? Sure, pretty easy. You get 10 or 110 offers, and there's no one or two of them that jump up and make the seller want to pay attention and do anything with, or the seller says, I've got 4 I want to go back to, but I don't want to accept any of them. The seller can take that form, and all of you are realtors, so you can use that form, Texas Realtors. I think it's 1926. And it basically says, in a kind and gentle way, we're not taking what you brought us. but we might take what you brought us if it said this instead of that. And so you, maybe one of them, you say a higher price and a further out closing date. And another one you say more earnest money, and another one you say more option money, and whatever the seller wants to do, the seller wants to go back to 4 of them with 4 different, each one its own set of facts, then that's what they would do. And that's how that works. And that
as opposed to just asking for highest and best offer.
Yeah, it's just a little way of being a little more specific than highest and best. And then the seller could go back to all of their offers, so they could pick 1 or 2, whatever. That's all driven by the seller. I mean, this is, you know, remember, it's not your deal unless it is your deal. But it's the seller. It's the seller.
Yeah, exactly.
Avis, I'll let you know that I just put a link into that form for everyone so they can click through and get it.
Oh, it is that form. Thank you. Thank you.
Yes.
And we'll get back to you on that lease question.
Yes, we'll get back to you. And then we do have a little selfish plug here at the end. Which of these courses satisfy the NAR Code of Ethics requirements? The NAR C2EX endorsement, our ABOR Code of Ethics powered by ABOR, NAR official Code of Ethics training, or all of the above? Drum roll, please. All of the above. Thank you very much, Susan. And the reason why we brought that up is because don't forget that your NAR cycle, Code of Ethics cycle, is coming up at the end of this year. There are lots of opportunities to take it at ABOR. Just go to our calendar. It's there. It's free. It does offer 3 hours of CE credit. So we're covering your bases. We do encourage you to get the C2EX designation as well. But don't forget that is coming up by the end of the year. And
and for those old timers, legal update 1 and 2 does not qualify anymore and hasn't for several years.
Yes, thank you, Susan. If you do not, you will be terminated. Your membership at ABOR automatically terminates. So
I need to do it. So I appreciate you bringing that up. I have it on my list of things to do, and I keep forgetting to make a time block for it.
Yes,
thank you.
Please don't wait till December.
No, I need to. I'm going to do it this summer.
Great. All right. Thank you so much.
Thank y'all.
Kerri, for joining us today. It was fabulous. And we hope to see you at our upcoming class on July 6th, where we will deep dive into all of these things.
Thanks, everybody.